Hello, my name is Kate Dittrich, and I am the owner of Dittrich Law LLC. I am an employment attorney that has worked with Selden for almost 15 years, advising the company on how to be compliant with all of the employment laws and make sure that our employees get what they are entitled to under the various employment statutes. So today, this is a short seminar on the Pregnant Workers Fairness Act. And the agenda for today is to discuss the background information about the law and how it differs from some of the other entitlements that were pre-existing. Then we're going to talk about the reasonable accommodations for pregnant workers that are provided under the Pregnant Workers Fairness Act, and then some prohibited actions at the end of what employers can't do under the new law. So background with the Pregnant Workers Fairness Act and some other anti-discrimination and accommodation statutes is this first section. And the Civil Rights Act of 1964 and the Pregnancy Discrimination Act of 1978 provide some basic protections to employees. They basically say that you cannot discriminate against someone because they tell you they're pregnant. So if an employee comes in and says that they're expecting a baby, they cannot be fired as a result of that. Additionally, pregnancy and some related conditions were also protected under the Americans with Disabilities Act, but only to a certain extent, because under that law, the employee had to not only be pregnant, but have an actual disability that rose to the level of protection under the Americans with Disabilities Act. So there were some protections that existed, but not complete coverage for employees who were pregnant and experience childbirth. So that's what the Pregnancy Workers Fairness Protection Act was intended to cover. It became effective in the summer of 2023. And it's a very short law. However, the regulations are pretty extensive, and the regulations came into effect just this past summer in 2024. Now, in order to understand the Pregnant Workers Fairness Act, I want to talk a little bit specifically about the Americans with Disabilities Act. And we have another training that covers the ADA more specifically. But under the ADA, an employee is covered by the law if they have an impairment that substantially limits a major life activity. So a major life activity can include anything like walking, talking, driving, showering, working, those types of things are considered major life activity. And if the individual has some type of condition, some type of impairment that substantially limits that, then they are protected under the Americans with Disabilities Act. The PWFA differs significantly from the ADA in that sense that the employee does not have to have any sort of underlying impairment or pre-existing condition or anything that substantially limits a major life activity. All they have to do is show that they are pregnant. Or that they have some type of related condition. So maybe they're attempting to get pregnant with fertility treatment or experiencing childbirth or postpartum, those types of things. So anything related to the pregnancy or related to childbirth is going to be covered under the PWFA. So this differs again from the ADA in that they don't have to have something in addition to the fact of being pregnant in order to be covered. Under the ADA, an employer is required to provide a reasonable accommodation if doing so would enable that employee to perform the essential functions of their job and would not cause an undue hardship. So, for example, let's say an employee has severe insomnia and the employee simply cannot get out of bed in the morning, is very unpredictable as far as when they are going to be ready and able to work. They may come and ask for an excuse from the essential functions of the job. They may say, I just need to come in at any point in time in the morning because I can never predict when I will be ready to work. An employer does not have to accommodate that if it is the case where no, they really need to be predictably at a certain place at a certain time. If you have a job where, yeah, it doesn't matter when you do it, just as long as you do it, then the timing isn't as essential as if you have a job that requires a certain place, the employee being in a certain place at a certain time. So if you have a job that the essential function is regular and predictable attendance, you don't have to let the employee simply say, no, I need to come into work whenever I want. In that case, you may want to do something else like discuss a shift change to say, okay, you don't have to come in at 8, but let's reschedule you to come in at 10 every day so that that regular and predictable attendance can be met by the employee. So the reasonable accommodations for the pregnant workers are a little different. Under the PWFA, it requires that employers provide a reasonable accommodation to an employee's known limitations that are related to pregnancy, childbirth, or related conditions. So as you will see here, there is nothing in this language that says the employee needs to perform the essential functions of the job, because there is a little bit of a different standard, okay? And then the accommodations are not required if they cause an undue hardship, and we're going to talk about that a little bit later. Again, as I mentioned before, it is not just pregnant condition, but any condition related to the pregnancy or childbirth. So things like fertility treatment, miscarriages, postpartum depression, anything that has any relation to the state of being pregnant or childbirth is going to be covered. And an extensive list of that can be found in the regulations. 29 Codified Regulations 1636 has that list if you're interested in looking that up. So accommodations can be any change in the work environment or the way that things are customarily done. So for example, if you have an employee who has a requirement that they show up at a certain time every day, you may have a issue where the employee has a limitation on doing that, okay? Even if it is an essential function of the job, the PWFA is different in that the purpose is not to enable the employee to perform the essential functions of the job. The purpose is to keep the employee working. So in that case, employers may be required to excuse an employee from an essential function of a job. So for example, if the employee says, I have morning sickness every day, and I don't know if I'm going to be able to come in at 8 or 8:30, sometimes 9, it may differ. You may have to provide that as a reasonable accommodation, a flexible start time as a reasonable accommodation under the Pregnant Workers Fairness Act. And the reason for that essentially is because the lawmakers recognize that it is temporary, okay? It's not going to last forever. It's not going to be a fundamental shift in the requirements of the job because the condition itself is temporary. So examples of accommodations. You may be required to provide more or longer breaks, changes in schedules, excusing travel requirements. Even if the requirement is something that is considered an essential function of the job, that may be required to excuse the employee for that temporarily while they are pregnant or experiencing pregnancy-related conditions. Uniform changes, providing leaves of absence or lactation accommodations under the Pump Act, even if they're not specifically required under the Pump Act, is something else that may need to be provided. So the Pump Act is another law I want to specifically mention. That is one that is also new. It is the acronym stands for Providing Urgent Maternal Protections for Nursing Mothers. That's the Pump Act. And that basically allows employees to have the time that they need to express milk after they've given childbirth. And anything related to that is protected both by the Pump Act and by the Pregnant Workers Fairness Act. So that may be a requirement as well. Undue hardship is the term that basically grants an employer the ability to deny the leave if it has an undue hardship. Okay, if the accommodation would pose an undue hardship on the employer. And that term has the same meaning under the Pregnant Workers Fairness Act as it does under the ADA. So here, an employer size their revenue, their other resources are all considered when assessing an undue hardship. So because Selden is such a large entity, it is going to be held to a higher standard, okay? Most of the investigators, the courts, the juries are probably going to determine, okay, yes, Selden, you can afford to have a temp employee come in while this person is on leave, or you could afford to allow this individual more rest breaks because of their pregnant condition, and that does not pose an undue hardship on the company. So that standard is really high, and we want to make sure that employees are provided with the protections that they're entitled to, unless it is something that is a very significant burden. So for example, if the employee needs a leave of absence under the Pregnant Workers Fairness Act, say they have hypertension or high blood pressure and they're put on bed rest and they need a leave of absence before the child is born. That would be covered under the Pregnant Workers Fairness Act, and you may be required to provide the leave, but providing paid leave may be a whole different story. That may pose an undue hardship, whereas an unpaid leave may be something reasonable that the employer can provide. Prohibited action, so things that employers cannot do. So the basic one is taking an adverse action. This is your basic discrimination and retaliation provision of the law that says if an employee requests an accommodation, if the employee seeks protection under the Pregnant Workers Fairness Act, they cannot suffer an adverse action, a termination, suspension, reduction in pay, anything to that effect, in retaliation for their exercising their rights or because of the simple fact that they are pregnant. So that's the basic prohibition. Also, the law has a provision that's a little different from Americans with Disabilities Act. And under the ADA, an employer can essentially pick whichever accommodation works best for the employer if there are multiple accommodations that are available. Under the Pregnant Workers Fairness Act, however, the employer specifically has to go through the interactive process. What's called the interactive process is a legal term, basically meaning you have to talk with the employee and figure out what's best. So you really have to engage with the employee to say, okay, what are your limitations? What are your needs? Can we accommodate? What different accommodations might work? And once you have had that conversation and hopefully documented that conversation, then you can require an employee to accept a certain accommodation after you've gone through that process. So unlike the ADA, the PWFA specifically notes that that interactive process is required. Also, there's a specific provision in the PWFA that prohibits employers from forcing an employee to go on leave if there is an accommodation that can be paid to allow the employee to keep working. So if the employee is in need of light duty or in need of more frequent breaks or anything else, even if it excuses the employee from the essential functions of the job, if there is some type of job that the employee can keep doing in order to continue getting paid, then you have to provide that rather than forcing the employee to take a leave of absence that will likely be unpaid and not covered by your short-term disability leave. So that is the basics of the Pregnant Workers Fairness Act law. And if you have any questions, feel free to contact me, or your human resource department is the first step. And we can work through to help make sure that you manage your employees effectively and know what their rights are and know what your rights are as an employee as well. Thank you for your attention today, and have a good rest of your day.